Well, good afternoon. You've just been seeing, of course, the situation around the Results Operations Centre ahead of next week's election. More from The Rock, as it's often called, in the next hour on Ballot Brief. In the meantime, still a huge amount of conversation around the Constitutional Court ruling this week saying former President Jacob Zuma is not eligible to be a Member of Parliament and cannot be a candidate for Thandiwe. Just yesterday, the Judge President of the Electoral Court, Judge Dumisani Zondi, who ruled that Zuma could go to Parliament, was asked about his ruling. In the Judicial Service Commission hearings, Judge Zondi said there was no right or wrong approach in dealing with cases like this. That's despite the fact the Constitutional Court overturned his decision. Thandiwe Seboletswe is a senior associate at the law firm Adams & Adams. They were part of the team that represented the Ahmed Kathrada Foundation. They were a friend of the court in this case. Thandiwe, good afternoon to you. You argued Zuma should not be allowed to go back to Parliament. You've had time to study the judgment. I'm sure you studied the Electoral Court ruling at length. What do you think the Electoral Court got so wrong in its judgment, if we look at the Constitutional Court ruling?
Hi, Stephen. I think that the Electoral Court's judgment and how it considered the issue of appealability and the interpretation of 47(1)(e) of the Constitution just was not in line with our court structure. It was not in line with the purpose of the section. And I think that's where it really got wrong. I think it took the proviso that says that a person is not excluded from the 47(1)(e) if they can still appeal the judgment. But of course, as we understand, the Constitutional Court is the final word on matters of law in our constitutional democracy. So Mr. Zuma, when he was convicted of an offence by the Constitutional Court, had no right to appeal. So I think the issue of appeal is where it really got wrong. However, it also, I believe, got it wrong regarding the issue of remission, because when Mr. Zuma's sentence was remitted by the president, it was not expunged, which would be the position if he was pardoned. It was merely something that said that his time was to serve had ended, but not his sentence was changed.
There's so much to it. I mean, I'm still intrigued, let me use that word, intrigued by the fact that on the Electoral Court there were 5 judges, 2 professors, 3 judges. That's how the court's made up. At the Constitutional Court, 10 judges heard the case. Now, all 5 judges on the Electoral Court went one way, for different reasons, but they went one way. And all 10 judges of the Constitutional Court went in the complete opposite way. I mean, I find that amazing.
It is amazing, but these things happen in our jurisprudence. I mean, the Electoral Court is a specialist court. And it was quite interesting that there were 3 judgments essentially. And then with the Constitutional Court, we have Justice Theron when a unanimous judgment. But these things happen in our jurisprudence. Judges disagree often and different courts disagree often.
I mean, lawyers, you're the 2nd or 3rd lawyer to say these things happen. I think the rest of us just scratch our head. Anyway, Judge Zondi said yesterday, and a difficult position for him, very rare actually. I mean, I don't know if it's ever happened before, that a judge in a very high-profile case makes a ruling. The next day, on the Monday, it gets overturned. And the day after that, the next day, they have to go to the Judicial Service Commission where they're being interviewed for a job. He got the promotion in the end. And they're asked about their ruling. So I wouldn't have liked to be him. But he says that there's no right or wrong way to approach a statute. Okay, maybe for lawyers there's no right or wrong way. But I mean, the Constitutional Court is right by definition. And the Electoral Court surely, by definition, was wrong.
That has to be the position. I mean, we must never take for granted the fact that the Constitutional Court is the final word on constitutional matters and arguable points of law. So I think I haven't seen his interview, so I don't know the context of his comment. But I do think we must always never take for granted the fact that the Constitutional Court is the final say.
There have been a lot of people who complain that it seems unfair that Zuma cannot be a Member of Parliament. And never mind all of the arguments in the court. I think there's a much more kind of fundamental reason why some people feel that, which is that everyone has the right to vote, and following the right to vote, you have the right to be a Member of Parliament. So you have the right to engage in political activity. How do you respond to that? That someone who has a right to vote can't be elected to Parliament? And I mean, I think for supporters of MK, for them, they think, well, we want Zuma to be there. Why can't he be? I suppose, to put it another way, it can feel to them as undemocratic. How do you respond to that?
I completely understand that position, but I do think we must always never take for granted the fact that we do live in a constitutional democracy, which is founded on values of the rule of law, which is fundamental for people who have to join the National Assembly, who are going to be making the law. And I must also say that the disqualification is not permanent. It ends 5 years after the sentence has been completed. And it does serve quite an important purpose, the disqualification. It says to the people that the rule of law is important in our country, and people who are serious violators of the law cannot be then be allowed to be the makers of the law. So I think we must always understand that the rights to the political rights are not unlimited, and the Constitution must be read harmoniously to say that just because you have the right to vote does not necessarily mean you have the right to hold office, for instance. For instance, we can consider someone of an unsound mind. Are they then, because I can vote for them, allowed to be members of the National Assembly? So I understand that position completely, but I think we do live in a constitutional supremacy with laws that must be followed.
It's been interesting, you know, the Constitutional Court, when it rules, sets precedents, right? And this, to me, is probably a set of circumstances that will almost certainly never happen again. The chances of someone who had been jailed by the Constitutional Court, then contesting for a seat in Parliament, I mean, I realise our politics is ever interesting. But, Thandiwe, I can't see it happening again. That said, are there aspects of law which have now been cleared up for good? Kind of have to use the phrase finish and clear here. But are there aspects of law around the definition of a sentence, and I can't believe we're having this conversation, but lawyers are lawyers, around the definition of sentence that have now been cleared up?
I think so. I think the judgment does quite a bit, actually. One, we now understand the effect of a remission by the president. We understand the proper interpretation of 47(1) and regarding the disqualification and the question of appeal. But I think it also affirms the Constitutional Court judgment in what's called Zuma 2, where it convicted and sentenced Mr. Zuma and the effect of such a conviction and sentence. So it says quite a bit in terms of what it held.
It's interesting in terms of the role that the Friends of the Court played. There were 4 of them. In a way, do you think that their arguments were important? I know the Black Lawyers Association also argued they wanted judges to recuse themselves. They dismissed that, not quite out of hand, but almost to it. Do you think it was important to be a friend of the court in this case? There was you, I think, a Corruption Watch, and KSAC as well. Do you think it was important that you were heard?
I believe so. I mean, this was an incredibly critical matter for our democracy, for our future elections. And I think if the court benefited from having different views, the different amici raised different issues. We focused on the proper interpretation of Section 47(1)(e) and also regarding the relationship between Section 19 being the political rights and Section 47(1)(e). And I think always having a friend of the court who has distinct issues that are critical to the court coming to a correct decision is always beneficial. So I think it was quite critical that the amici played a role. Even the Black Lawyers Association, I thought their submissions also were beneficial.
Thandiwe Seboletswe, thank you. Senior Associate at Adams & Adams, part of the team representing the organisation, the Ahmed Kathrada Foundation. They were a friend of the court in that case.